I've tried to make this as less technical, meaning less legal as possible, because I'm aware that a lot of us in the audience are non-lawyers, and therefore it wouldn't help to get into a lot of legalese in terms of addressing the issues. But the US Supreme Court did hold the view about what patents are, that Congress intended the statutory patentable subject matter to include anything under the sun made by man. And patent protection of computer software, generally speaking, is founded on giving protection to a solution of a specific problem in the field of technology, ICT, obviously. I don't know if the slides are too small, but you should be able to get copies of the presentation thereafter. My apologies if they're too small for those at the back. We've already been given a view on what is patentable under Kenyan law, and so I won't dwell on that, but what I want to highlight is the element of the exclusions. Now, it was said that in the earlier Patent Act, the computer programs were excluded. But today, the exclusions include discoveries, scientific theories, mathematical methods, but do not include computer programs as an exclusion. However, my thoughts around this are that the essence of what a computer program is really a mathematical algorithm. And therefore, in a sense, then it is arguable that it's excluded, but computer programs, by its very nature, software, is a mathematical algorithm that is run in a certain way to achieve a certain purpose. So it may be excluded on the basis that it's a mathematical program. And we look at how a few different countries, if you like, or regions have dealt with that issue. Under English law, the exclusions are fairly similar, but what I'd like to highlight is that there is a proviso at the end of the clause on exclusions, which says that a computer program, provided that the patent relates to that thing as such, will not be excluded. So essentially, if you have a computer program, it's excluded if it relates to the patent application as such, meaning you're trying to patent a computer program for what it does. So you have this computer program, perhaps how to fill in your rooms in a hotel, or how to restock. I'm trying to use very basic examples here. How to restock your supplies in your institution. Now, you can't patent it as such in the context of, I have a computer program, when I run out of milk, when I run out of bed linen, then it prompts a reminder, and then we have to purchase that. What you could do, obviously, is to have it registered as a copyright. And we'll see why that's really important, that exclusion in English law, where then computer programs are excluded if they only relate to the patent as a computer program and nothing beyond that. Some of the arguments that have been raised against software being necessary for patentability, and this is the substance of what we're talking about this afternoon, include some patent claims are speculative and have no bearing on the real world or practicability. If you look at perhaps the very essence of a software developer, the typical image, and Dr. Isaac Rutenberg gave us a very good indication about how it works in Silicon Valley. And speaking of which, I remember a government trip that I attended once in Silicon Valley, and we were these government officials all uptight in our dark suits walking into the Google campus and finding kids in jeans and t-shirts, some were on chairs just chilling, some were having snacks. And I remember one of the guys we were with asking a gentleman who was in a chair having a massage, "So are you working now? Why aren't you at work?" And trying to understand the whole concept of the very laissez-faire approach to work. And you have to understand, companies there will make the environment at work very conducive because they spend so much time there. And obviously they come up with very exciting things. But those kind of people perhaps sometimes come up with things that may not be practical to the real world. It only needs to find perhaps someone who can help commercialize or make it practicable, but sometimes the argument against software patenting is that it has no practical application. Software patents sometimes have been viewed as being pursued only by large and wealthy corporations who splurge their cash on prosecuting and defending patents. So essentially, if I was a small-time developer, why would I want to go into patenting? Because there's this huge IBM, Philips, Electronics, who spend a lot of their money in patenting. In any case, one of the disadvantages or the arguments against it is that it costs a lot. Other cons include a large percentage of ownership of software patents by large firms, disadvantage smaller firms, because then if you're a large firm having a whole raft of software developers, you go ahead and patent whatever technology you have. And I, as a small-time developer, or a small developing house, may not have the sort of money to fund those activities. It might stifle innovation because you guys will go ahead and patent as many inventions as to make it impractical for me as a small-time user to patent things that might be of benefit to me in a smaller version. There are steep costs that are associated with licensing proprietary software. So essentially, if you're a small-time user who doesn't have patents, or you want to utilize a certain patent for a certain purpose, the cost of accessing it through licensing can be very prohibitive. The patent application process and eventual grant sometimes can be interminable. If you have a process which is not clear or that has a series of rejections, then people who seek to get these patents often get discouraged. The costs of filing are prohibitive. One of the fundamental things, and this was mentioned earlier today, it's a challenge to peruse prior state of the art, which is fundamental towards trying to establish the inventive step. And since, how do you establish the prior art in software inventions? I mean, if one Kamau sitting somewhere in a lab in Nairobi comes up with a certain invention in software, which perhaps is being replicated by Julio somewhere in, say, Venezuela, how is he supposed to understand that this patent has actually not been registered in the context of prior art, publishing, etc.? It's very difficult to establish what the prior art is, since they're not easily available or accessible. Most of the companies that apply for patents are not actually inventors. We've been told earlier today about patent trolls, companies who sometimes don't do much other than hang on to their patents, hire very expensive lawyers to look around and find out who's misusing, who's infringing on my patent. And essentially what they do is come with a big stick, and sometimes if they're kind, they will let you know that you must license or else we'll go for your neck. If they're not kind enough, they'll send you a cease and desist letter. And a cease and desist letter, for those who are non-lawyers, is you need to stop using this patent or infringing on my patent in these terms because it belongs to me. I have the bundle of rights. And I recall something I read 3 days ago about the kindest cease and desist letters by very nature don't tend to be very nice. They're sort of bordering on nasty. And there was one American lady whose cease and desist letter was said to be very kind, very angelic, asking the person who was infringing to kindly refrain, and if they have any questions they would like to discuss further, please get in touch with me. We'd be happy to discuss how we can help you out. Normally they're not crafted in such glowing terms. By way of example, there was a recent case, again, as a lawyer I can't avoid referring to case law, and you'll understand hopefully subsequently in the presentations that one of the ways of setting standards and the principles of what is patentable and not patentable in software technology is by the series of what patents are granted and what patents are not granted. If you look at case law, both in the US and in Europe, based on what is granted, a structure or a precedent is created, which then informs either the patenting office or the courts in which appeals are made against or for. So generally, one of the things that perhaps we have not had sufficient numbers of, and the MD of CIPIT this morning spoke about the number of patents that we have. You'll notice that on the whole, they're very lower numbers. Perhaps we're not, at the place where the US is, but even then, you need to have as many applications as possible, because that way then you test their mettle. You get them to make rules, fundamental regulations, if you like, on what is and isn't patentable, especially for software, which is still a very, very gray area. So in the Monsanto case, the award by the court against DuPont in favor of Monsanto was up to $1 billion for a product that Monsanto that Monsanto never brought into production. So Monsanto, in a sense, made $1 billion out of having that patent registered in their name. I mean, it's obviously a very good way of making money, if you see what I mean. Prior art perceptions of the software, prior art perceptions within the software community. Sometimes patents are objected by some in the technical community on the grounds that, come on, this is easily developable. I mean, if I sit down with my computer for 3 hours, I can come up with this patent. So come on, I mean, that really shouldn't be patentable. Let me just try and rush through this. Duration of patent sometimes is too long. That has been argued, but if you look at the duration of patent protection versus that of copyright, you'll realize patent is far, far shorter. I mean, it maxes out at 20 years, whereas that for copyright could push on to 100 years if you take the life of the author, and if the author lives to be 70. and then another couple of years after that. You can see how long that can run. Patenting of software can reduce competitiveness in society, because then what happens is the use of those patents, the use of that technology is restricted, unless, of course, I enter into licensing agreements with the patent owner. So it becomes very difficult for me to do anything. So in a sense, you can argue that it reduces competitiveness, especially in the case of something that has great value to the society, something which, and at the end of the day, whatever patent you have, you're going to put a value to it. And so if there's a price associated with it, and there's only one person or two people who have that benefit, then one of the ways that competition helps a society is by reducing prices, enhancing quality, etc. Knockoffs, it has been argued, can lead to innovation. So why should we patent software? One of the biggest patent cases of the century going on currently is Apple versus Samsung, for those of you who've been reading the news. It's been reported quite a bit. Some of the arguments, and just going to show how sometimes knockoffs can lead to innovation. Apple claimed that the iPhone changed everything. I mean, it was the next best thing after sliced bread, to use an example a lot of people use. But then Samsung began to build knockoffs. I mean, Samsung had different types of phones before the iPhone came in. The iPhone came in, and suddenly Samsung decided to start building what Apple calls knockoffs. Now, whether or not they're knockoffs, those of you who have Samsungs can testify to that. But Samsung Samsung was accused of copying Apple by the look and feel. So if you look at a Samsung phone versus an Apple versus an iPhone, you know, there's a sort of similarity in how it looks, how it feels, even though perhaps there are certain distinctions. So Samsung continues to argue that, at least in their preliminary opening arguments, that there's already a lot of prior art. This software, this technology was already in existence. Come on, how could Apple go ahead and claim that they own the patents, or that we were building knockoffs? It was already there, and therefore there was nothing that restrained them from utilizing it. The first iPhone is reported to have had well over 200 patents registered on the iPhone, on that one iPhone alone. You can see what the abundance of how the response of patent offices to software can actually help build a software industry. Quite extreme. Those that support patenting of software would argue that if patents are allowed, then it creates the opportunity for employment and economic growth, because obviously what happens is you have to disclose everything in your patent application, because then it allows society to benefit overall. So once your term of protection ends, then other people can benefit. Other people can come to you if you don't feel like commercializing or developing it further, and build on it. So it actually helps an individual, a company, and the country as a whole. From a historical perspective, the rationale for patenting computer hardware has been accepted. As you saw from the examples given by the chief patent examiner, computer hardware, straight off the bat, if you are Apple building your first, see-through, I don't know if those of you remember the desktops that Apple used to build way back when, they had sort of those see-through covers, very easy to patent that. But, talking about software patents, how do you patent software? And that's why it was so far down in the food chain, as Bwana Juguna said. And so the same underlying reasoning remains for patenting of software. I still think there could be a reason, especially because of the confluence that now exists between hardware and software. You can take your hardware, have it there, but without the software within it to help give it feet, if you like, to give it the ability to process, then all you have is hardware. And you can patent that and sell the boxes. And that's why IBM, who are also known as the big blue boys, came with that whole, it was all about hardware. But newer, smaller, younger companies came in with software, and software is really, really big, perhaps much bigger than hardware, because there's nothing new anymore about hardware. Perhaps, just the style of how you make it, make it more sexy this time, make it, have curvatures, et cetera, et cetera. The best way to encourage innovation, as another pro, is to protect the expression of ideas of the innovators. So really, if I'm an innovator, then I need to be allowed, I need to be protected to be allowed to maximize on my patent. Innovators who put in hard work require just and fair compensation. That's pretty straightforward. Now, I just want to discuss perhaps two things in terms of where the twist, where the rub comes in terms of software patenting. Novelty, as has been said earlier, novelty, inventive step, industrial application. Those are the key things. Now, in terms of novelty, essentially it's something that shouldn't be already known, all right? Shouldn't form the prior art or state of the art. So ordinarily, before you make your patent application, you need to be certain about that. Now, it's not very easy to establish prior state of the art in software, as I've indicated. So if this is not possible, then should we be saying that patent applications should be wholesomely accepted or they should be wholesomely rejected? Is it possible that a skilled code writer, by observation or analysis, can discover and reproduce code that is patentable? So if we go ahead and say we'll allow patents like, say, they do in the US for business processes, are we saying that a certain Otieno sitting somewhere in Kenya with the relevant amount of skill can't do that? In establishing novelty, certain issues should be considered, and this is all from the context of software. I'm trying to sort of move beyond the excellent presentation made by Jiguna earlier to address some of those unique things. But in software labs today, the atmosphere is very collegial, and what tends to happen is that code writers talk to each other a lot, they compare notes, they do things together, and that's why we have this, iLab, MLab, NILab, etc. So what happens in the context of, I'm coming up with this really, really fantastic code, and I shared it with Tom, Dick, and Harry. Does that include, publishing? Does that include making information about this patent available as a prior art, and therefore my patent should be rejected? So perhaps there needs to be a different consideration, and perhaps as I'm talking, these are some of the issues that I believe CIPIT ought to start considering. Is there a different twist to look at how software patents, and I certainly think if software is to be patented, there needs to be a slight divergence in terms of how it's appreciated. So what form of prior publication is concerned? Is it merely usage? Is it oral? I was at iLab sitting down, writing this code, and I spoke to somebody about it to sort of get a validation about my code. Is it something that I actually wrote down and therefore will be rejected on that basis? When a patent application is made, what is critical is the priority date that's given. But just to establish that the priority date in terms of your patent application is to establish when the application was made and not, vitiate the application because of, that would be considered making it available or publishing as a prior art. Inventive step, what is the inventive step in the context of software patenting? That needs to exist. So regard must be had to the state of the art. And what's critical to remember is that the invention should not be obvious to a software skilled writer in the art. So essentially, the person who's seeking to patent this software, in my view, should have a high and far out level of understanding of skill that is not available to the average skilled software code writer. It is relevant to the assessment to establish how the inventor reached the result, and I think this is a standard requirement under ordinary patents. The inventive step in software patents may lie in a new way of doing something, and therefore the invention should be viewed as a whole against the state of the art as a whole. Sometimes in software patenting, it's not about a completely new process, and this is one of the more difficult things to establish because in Kipi's view, perhaps it's important to establish what whole new thing are you establishing, but perhaps it's a small component that has changed, which still meets the requirements, and so should it be rejected? The state of the art could be treated either as that which is made freely available to a single person. So if there's a single person who knew about it, perhaps that would constitute being made available and therefore is available in prior art. Commercial success can also be used as a yardstick to measure inventiveness, but only if the invention is the cause of success. So it's arguable that, come on, this invention has proven so successful that working backwards, I think it makes sense, or the rationale exists for patents to be granted. The requirement that the patent should be obvious tends to be a very big challenge, and like I said, because of the difficulty in establishing or going through prior art. So essentially, the skill level of the person who would have been able to do this outside of the person who actually created that code should be established. A software invention should not merely replace an existing technical and physical solution with the same solution using a computer and a software. So it doesn't mean that you're going to take something that exists in mortar and brick and create a solution in software code, and that's all that lies in terms of the patentability of that software that you're seeking. It should be that that which is not obvious to the average software engineer, and this is in contrast to where a general purpose computer is transformed into a special purpose computer once it's programmed to perform a particular function. So essentially you have this computer that runs programs doing certain things. Say, again, to use the example I'd used earlier, you have this computer that runs a system that establishes how many students are registered to take different courses in Strathmore University. You take the same computer, plug in a different code, and the same computer can offer you different services. It can establish, perhaps, it can help establish the number of the number of rooms in a hotel or in a hospital. How many patients do we have? Let's move on to exclusions. Like I mentioned at the beginning, exclusions are some of the tricky aspects. Besides being novel, having the inventive step and industrial use, then it must be clear that that patent application does not fall within excluded matter. We've talked about, at least in my view, the distinction of computer programming, which can still exist in mathematical formulae. Now, a computer program, like I said earlier, is a series of mathematical instructions which is processed in a way that theoretically can be processed by the human mind. So is it possible to argue then that under Kenyan law, yes, we do not exclude computer programs, but computer programs are essentially mathematical algorithms. So then, are we still excluding computer programs by the back door? Perhaps not, because the two ways of looking at it are that it's not excluded and therefore can be patented, but then is there a reason why we don't have very many or any, for example, computer programs that are patented? Could we work backwards and argue that because we don't have them because there's still that view, that perception, whether or not the law has been amended? Or having, should it be specified in the law that, computer programs, and like I said, English law has that very unique proviso that a computer program will be excluded if only it relates to the patent application as that thing as such, meaning it's merely the computer program and nothing more. The core part of a software-related innovation may lie in an apparatus, a system, an algorithm, a method, a network, the processing of data, or the software itself. So there's different versions of how you could look at a software-related innovation that is submitted for an application. A computer may utilize the program in it merely as a source of information in and of itself. So if you have this computer program which is merely a source of information and is not doing anything much, then perhaps there's a good case against the grant of patent, all right? However, where the same program is used to change, control, direct a step as part of an overall operation, say in a manufacturing process. We have been sitting and designing sheet metal that is used to make cars, all right? Or we've been using we've been using a manual process to cut out the sheet metal that is used to make the car that you rode in this morning. But what we're doing now is taking a computer program and plugging that into this whole manufacturing or industrial process that allows that to be done by robots, which are controlled by program, and a person sitting in a certain terminal somewhere can control that whole process. So perhaps then there's a case there for patentability of that computer program as in the context of the whole process, because then what's happening is the process has changed in terms of the utility or the usage of it from the point of view of physical use versus non-physical use to the extent that it's a computer program controlling a robot. Therefore, a particular computer program may result in a series of actions or effects which overall can be considered to meet the standard of patentability. And I think that's one of the basic things I'm saying here today, that perhaps a higher level of assessment needs to be created just uniquely for computer programs, because if they have a technical effect, they have an overall technical aspect of it changing within that whole process or creating of that product, then maybe there needs to be a consideration for patent. Software code is the boundary of what is and isn't patentable, and therefore a novel approach to looking at patentability is necessary. This has been mentioned in passing by the earlier presenters, but essentially the US Patent Office and courts in the United States have shown their readiness to allow patents for programs as such. Now remember, under English law, and this actually stems from the European experience, that registering or trying to apply for a patent for a computer program as such will not be allowed in Europe or in England under English courts. But if you look at the US experience, then what happens is you can actually register a patent for a business process, and you have very many applications by companies, say even like Merrill Lynch, where then a lot of companies like that will register patents that allow them to assess real-time data, commercial data of companies, or whatever it is that they do as a means of generating revenue, and therefore that would relate to a computer software program generating information and being nothing more than just that. And therefore perhaps that's the rationale. It's information that will allow you to make a judgment call as a person holding funds for investors to decide whether or not to invest in certain companies, etc. The general rule of thumb, therefore, in the US is that patents are permissible for computer programs which produce purely informational results and involve no technical means other than the ability to use the program on a standard computer. The European experience is guided by a lot of what happens at the European community, and the European Patent Office issued guidelines. And these guidelines essentially allowed claims which involve a computer program if the overall invention made a contribution to the art that was technical. So the key word here is technical. Did the software program, did the claimed invention in software make an overall contribution to the art which was technical? It may not have been anything more than that, but if there was a technical contribution, then perhaps the argument is, based on these guidelines, that patentability should be granted. English courts have then gone further and emphasized the technical character or the technical effect of the program. Now, I've listed there a couple of cases. Again, like I said, I couldn't avoid it as a lawyer, but these are some of the really seminal cases in terms of how software programs were applied, software program patents were applied for and were either granted or not granted. In Cork and Sturzel, again, just to rush through, this essentially was a standard X-ray apparatus which was linked to and controlled by a data processing unit. So essentially what was at the heart of the claim of the patent was a computer program. Patent was granted. Vicom's application, essentially it was a general method and apparatus for processing digitized images within a computer. And this process would either alter the image, it would sharpen, it would smoothen the edges. Now, it had been denied by the Patent Office. And of course, when the application was denied, an appeal was made to the Court of Appeal. So the Court of Appeal held that, no, we don't think the Patent Office did the right thing in denying patent. They really should consider it on the grounds that there was actually a technical effect which was submitted in terms of the prior art. In IBM, and we've heard about the number of IBM patents that are owned by them. The board, the technical board, again, this is in the UK, held that a computer program claimed by itself is not excluded from patentability if the program, when running on a computer or loaded into a computer, brings about a technical effect which goes beyond the normal or physical interactions between the software and the hardware on which is run. So ordinarily you will have a confluence of software and hardware. So what the technical board here was submitting is that if the program brings about a technical effect which is novel, all right, not the traditional, this is where software meets hardware. But if it's something novel in terms of technical effect, then it really should be granted patent. Sorry. I've spoken about Merrill Lynch. I think I'll just let you read them later in terms of the presentation that you will get. But essentially, this was Merrill Lynch in the United Kingdom and not in the US. And essentially, they set up a trading market in securities using a known computer which could be suitably programmed using known techniques. And the Court of Appeal held that it was excluded, but not necessarily because it was a computer program. It was excluded because it was a way of doing business. Now, if this application had been made in the US, guess what? The result would probably have been different. In the United Kingdom, a committee was set up together by, obviously chaired by a gentleman called Banks, hence it was named after him. But essentially, the Banks Committee proposed recommendations for opening up software programs to patentability. Now, because the huge number of applications that came up and there was no very clear standard on how they're granted or rejected, it was felt that some policy direction needed to be given in this regard. And so the recommendations of the Banks Committee were that how does a patent office conduct a search of applications for program patents, even if the research material was made available in a suitably classified format? And we understand and know that searching for prior art in computer software is really difficult. But even if it was, how do you conduct that search? It's not actually cast out there in definitive terms. It is considerably difficult to determine issues of novelty and obviousness, and therefore, because it's that much more difficult, perhaps a new standard of assessment should be set out. how does one establish this true state of the technical art? It's arguable that a distinction ought to be made in the applications for programs per se and for the inventions of the kind that are claimed as computer-controlled steelworks. I gave you an example about how, car design, sheet metals can be done. In fact, as a matter of example, there are actually applications where a patent was granted for a computer program which this must have been from a French company, I suspect, because of the history they have with the perfume industry. But essentially, the computer program produced a technical effect in that it changed the smell. And because it changed the smell, patent was granted. There was yet another case where, the use of the computer program produced a technical effect in the context of changing color. And because the color changed, patent was granted. Very sort of borderline illustrations there. I think the summing of it is that a program on its own should never be accepted for patent, and hence the genesis of that provision in the English law. But an invention should qualify for patent if it utilizes a computer program, and in its operations should not be disqualified on this ground alone. If there's a whole process which somewhere in there utilizes a computer program, then certainly should not be disqualified for patent. Some of the experiences, and I'm just about to sum up this presentation, but I spoke to some of our peers in the software code industry in this country. Some of them will sit at iLab, NILab, etc. And to find out what the challenges are, these are some of the responses that they've been told software patents are just not patentable in Kenya, period. So, we don't waste time seeking patents. Some of them have said that how do you prevent infringement? Fundamental issue, which I think is true. Prevention of infringement is difficult and not worth the trouble. Now, unless you're a patent troll, then it's really difficult for you to find out who is. And I think the natural reaction is, if I put it out there, you're required in your application to be abundantly clear, absolutely crystal, so as to enable your application to be granted. But, the thinking is, if I do this, then, someone will copy my idea. The knowledge gap exists in the understanding the state of the law. There's really a huge blank in terms of how this process can be done. I think perhaps this is where CIPIT perhaps can help, and institutions like Strathmore University, creating fora like this where issues can be discussed, issues can be made clearer. There's no motivation with some of the software code writers to tackle the lengthy process that is registered in a patent. It has been argued that patent registration is very costly, and the cost could be about 12K. I put a question mark there because I'm actually not sure. Which should be embarrassing to me as a patent agent, but very difficult because I try to sort of focus on software patents. But nonetheless, there's always a fear of potential theft by larger bodies. There's a lack of confidence. Sometimes some of our small code writers feel that, come on, I want to be taken seriously. I have this really bright idea, and you should see some of the verb with which some of these code writers explain their ideas. There's a gentleman who I spoke with and we were handling his patent application, and they live these things, man. They woke up one morning and an idea popped and they wrote this thing out down. But sometimes the lack of confidence stems from, man, can I do this without someone stealing it? Or will this really be commercially viable? And sometimes that is the challenge in terms of trying to encourage them to apply for patents. Lack of capacity to undertake a large software job that will involve patenting. A lot of the work that sometimes goes on is very small scale, and start in different places. But perhaps you need to find a place where, manufacturers or institutes or companies, well, IBM now is setting up a center here. Companies like that can actually fund huge software industry things, which may not be available to you as an individual code writer. The lack of a forum with existing companies to help, discuss. You're doing this, you've been doing this, you're big core oil industries, you've been doing this for so many years. How can I help you? Obviously, my time is not running out. I think some of my recommendations in summing up is excellent. Thank you. It's just giving me 40 more minutes, so bear with me. Most software patent, I think there needs to be a whole lot more software patent applications. Just sitting back and saying, we're told they're not granted, or I'm discouraged, I don't think we can do this. How the US and how Europe has grown is by being peppered with numerous patent applications, and that way they are forced to make a decision saying, you know, we need guidelines, or these are the kind of applications, because it's difficult to set a guideline even if, you know, the chief examinations officer came and said, this is what you can, and we do have the guidelines in the act in a sense, but you have to test the law against real life situations, and sometimes the real life situation might be far removed. So when you have real life cases, applications, if you like, then you know, the patent office and our courts, as it were, are forced to contend with how to create a fundamental rule. And that's how I think, as lawyers, case law informs the decisions we make and that sort of thing. I think that the CJ needs to be lobbied, and I think we need to, I'll congratulate Kekobo and Marcela Uma's organization for doing this, you know, lobbying the Chief Justice to create a specialist IP and technology bench. We do have, you know, family benches, we have those dealing with children, we have those dealing with commercial matters. But one of the challenges you would tend to have is a lack of proper succinct understanding in terms of how to address this issue. So having a bench that is unique to IP and technology would certainly be helpful. I think having a forum like this, and many more where software developers can interact to discuss perhaps the law, the policy applications in terms of Kiptinness would be very helpful. The conclusion is fairly short, but I guess I want to delve into that. What I'll just highlight is that people will take it. And I think I'll sum up by a quote by one Peter Hydgens. He says, when we work, natural law says we have the right to own our work. To let others steal this is to destroy the basis of civilization and to cast us into slavery. Therefore, if I cut a tree and make a table, it's mine. If I write a story, it's mine. If I invent a new compression algorithm, guess what? It's mine. When someone takes my ideas, then that's theft. And a just society must punish theft or the society falls apart. Therefore, software patents are thus a natural and necessary protection for original ideas. Thank you very much for your attention.